thought we'd have a quick chat with Adrian today, our Senior Dispute Resolution Litigation Solicitor and also mediator, and talk a bit more about the mediation services that we can provide now, and how the mediation process works generally.
Sure.
So I think there's just to start off, I think there's quite a difference between the traditional court-based litigation process, which Adrian's very experienced with. It's a hard-nosed litigator where required, but also takes a softer approach where needed and is used to getting negotiated settlements at all stages of the process with clients. But Adrian in particular feels that a lot more can be achieved through mediation. Well, I'm kind of pre-answering the questions here, and also that there's more impetus, particularly there's more requirements, more pressure in different ways from the courts for clients to go through the mediation process.
That's correct, yeah.
So yeah, I've just set the scene basically a bit there, but yeah, first of all, Adrian, so you've got years as a litigator, you've seen the process inside out. Yeah. Why do you want to do more mediation now? What do you think is so good about the mediation process?
Well, I think there are so many different factors that play into this. I mean, litigation is hugely expensive, hugely time-consuming, and usually damaging. I don't think I've ever had a client who's come out of a litigation process and said, I'll be quite happy to do that again. You know, and it literally doesn't happen like that. And I think that, I mean, costs are going up, the courts are hellishly busy, the process is very time-consuming and laborious. So mediation offers an opportunity to cut across all of that. And why does it enable you to do that? Well, the thing about mediation is that it's a without prejudice process. So people have an opportunity to ventilate, to put their case, to position their case, to seek empathy perhaps from another party, to have kind of open and frank discussions with the mediator, and you know, open and frank discussions with the other side. None of what you say in mediation is ever disclosable, and so it's a very useful forum. So you know, when you go to court, of course, you're in front of a judge. A judge is there to make a decision based on what he hears. People are usually very guarded about what they say because they want to tailor their evidence and so on, and give themselves the best opportunity. Mediation is a much more fluid, open process, and I think that what mediation allows parties to do is to move from positions, to make adjustments to their positions in a way that they literally can't do in litigation. Just
get a lot more done, achieved in a shorter space of time than have this horrible process with the letters going back and forth and trying to go through the courts.
I think it's fair to say that mediation, I think there's a time for mediation, and I'm not sure it's always the right time to do this at the beginning of a dispute, but there is certainly a time in the course of a dispute to do mediation. And as you pointed out, the courts are encouraging it, encouraging rather than threatening and positing that people absolutely must do it, but it won't be long before that happens, I think. And I mean, I've certainly found in recent months, last 6 months really, that opponents are a lot more keen on the idea of mediation because they have to be. We all have to engage in that what they call alternative dispute resolution options now. Consider whether we can find a way through. Judges are expecting it, and it won't be long before judges are demanding it, as I say. And even now, judges will make orders that identify that the parties must be encouraged to look at mediation as a proposition. You know, and frankly, if you go to a trial without having looked at any form of mediation or other alternative dispute resolution process, then the judge is going to be very, very unhappy indeed. And that will sound in costs and all sorts of other penalties. So, you know, it's critically important people look at it.
I'm just wondering how, leading on from that, if you've got the courts who are increasingly putting influence and pressure on people to go through the mediation process, but how, in your experience, have you ever successfully persuaded clients? Because it has to be, I guess, your client that you're representing in the litigation dispute resolution matter, but you've also got to get buy-in from the other side?
Yeah.
How any?
Well,
sort of-
I mean, I think that all lawyers are open to it now. I mean, there can't be a litigation lawyer in this country who doesn't know that mediation is a process that they have to look at. So encouraging your client to look at mediation, that's not really, I've not found it a difficult conversation to have, because you're very often at a point in a dispute where a client has spent an awful lot of money, stands the prospect of spending even more money. There are risks in litigation always, despite even if you've got the best kind of case, there's always a risk.
Yeah.
And so clients want to mitigate that risk. The other thing to say is that most people don't want disputes. I mean, aside from what we think, and it's great for us from a business perspective, but most people don't want dispute. People want solution.
And do you, in your experience, where you've seen mediations, whether it might be one that you've referred to a mediator we know, or you've been involved with yourself, is there a much better feeling at the end of it? They've got a resolution, the parties have some kind of relationship at the end of it, rather than absolutely hating each other's guts.
And that's a good point. I mean, a lot of mediations will settle on the day. Some mediations won't, but it's a conduit for discussion, so discussions can go on afterwards and a deal can be struck later. It's always nice if you can get a deal on the day. You can get paperwork signed, which then means it's binding, otherwise nothing is binding in a mediation. It is a really, really good process, and I found that the buy-in from solicitors is good, buy-in from clients is good, because they can recognise the benefits of it. Sometimes it seems, I find on a mediation that nothing much happens in the morning. It's all a bit kind of loose, and people kind of there's a bit of trepidation often if you've never been involved in it before. Can it really work? Is it all a bit too fluffy? You know, it sometimes can seem not very oriented or not very specific. But I think that's the beauty of it, because it enables a lot of the kind of, I mean, most cases come down to one or two specific points, and there's a lot of fluff around litigation. So a case can look this big, but actually it's much, much smaller in reality.
Okay.
And then people end up talking about all the things that matter to them. So, you know, litigation is really emotive often. You know, as you say, if business partners are involved in a dispute, they don't want to be involved in a dispute. They've been chums before, or family, or they've been great friends or whatever before, and business partners, and so they don't want a continuing dispute. And beyond mediation, for sure, you know, you can rebuild bridges, and it must be a better option than well, it is a better option than litigation in most circumstances.
So, as with anything that works, there's a process involved and formalities.
Sure.
I wonder if you could give us an idea of the steps involved to set up a mediation for it to run successfully.
It's extremely simple. That's the beauty of it. So there are mediators up and down the country who are registered with the Civil Mediation Council, because it's civil law that I deal with. And they will either be lawyers, or very often they're not lawyers, and they will have had experience of practice in some way, shape or form, and so they can bring those skills to bear. They would have been on accredited courses, which I've been on, and so they'll be registered by the Civil Mediation Council. Booking a mediator is just a diarying process. You're sent a mediation agreement, which the parties sign. You pay your money up front to the mediator. Some of your fees will come back to you if you cancel within certain time frames, but generally if you're paying, you know, those fees will be done. The other thing is that both sides share the cost of that equally, and people investing money in a process will often give their time and effort to that process. And so there is a commitment on both sides to do that. Pay the invoices. The mediator will come, and either you can do a virtual mediation or an in-person mediation. They work equally well.
So virtual one now with video conferencing facilities,
with
that all works pretty well.
Stuff. It's very
easy to set up.
Yeah, and what they do, you see, is to have you can have a group session, which is a plenary session. They're less popular these days because people who are locked in dispute generally don't want to meet each other.
Yeah.
But you know, the mediator can put people into breakout rooms. He can liaise with them independently of the other party. Nothing you say to a mediator is disclosed to anybody else unless you give authority for that to happen.
Yeah.
So it's a truly, well, I don't like the expression safe space, but it is it's a safe space. You could discuss things with the mediator.
That kind of relates to the next question. I was going to ask the next question is about how do you maintain neutrality? Which like, as solicitors, we've always got to avoid conflicts of interest, whereas now you've got two different parties. You're the mediator, and you've got a.
Well, I think the thing about mediation is that it's not a judicial process. So the mediator is not there to make a decision. The mediator is not there to decide what's right and what's wrong. It's just as a conduit to get the parties to move, and that doesn't mean moving off your position necessarily, but moving towards settlement rather than towards conflict, which is what the litigation process, unfortunately, demands. You know, you get two solicitors in a room, they'll argue. I mean, that's just the way it is.
What's the typical cost of a mediation process?
Okay, so that depends. That will depend very much on the value of the dispute. So mediators typically charge fees according to values of claims. Okay. But some claims, of course, don't have value necessarily.
Okay. Does it also involve having to read a lot of information and being
you'll pay a fixed fee for a mediator. So typical fees in a sort of dispute I handle are probably £1,500 to £2,000 per party. And if the mediator is registered for VAT, that's on top, of course. But that'll be a flat fee. So you'll get the mediator then. That will enable them to read into the papers, enable them to be present for the day, probably for into the night as well. You get a fixed number of hours, and then you pay additional if it goes over. I always like the idea of getting mediations done in a day. Because nobody works very well after hours. If you sit in a room for 10 hours or 12 hours, you're never going to make good decisions.
It'll just get worse and worse, I guess. So do you try and sort of push people on and sort of say this is the time?
It has a natural. It has, as I say, mornings tend to be a little sort of fact finding, really, and then things start to sort of creak and break, and things start to move. Kind of after lunch, when people realise that the clock is ticking a bit. Sometimes one party will have a deadline. They might have to be somewhere to pick up kids, or have something that they've got to do in the evening. So that can be a catalyst as well. I think the thing with mediations is mediations can go for more than a day. You can have a 2-day, 3-day mediation.
Depends on the complexity, I guess.
Yeah, there's no desire to rush it, but I think the thing is that the mediator will understand the dispute when they come to the mediation. Both parties know the dispute. So everybody's on an even playing field. And as I just said, the mediator isn't there to decide anything. The parties know what they want. It's just a case of the mediator trying to find commonality by speaking to the parties individually, areas of possible agreement. And the interesting thing about that is that you very often think you can't agree anything. But on a list of, say, 7 things, there might be 3 things you do agree on. And those
focus
are
on those, And at the mediation, will it be common for the parties to have their solicitors present as well?
Yeah, that is common. To answer your question. But the focus is very much on the parties. Although I'm a solicitor and a litigation solicitor at that, I think lawyers do get in the way of disputes. They get in the way of settlement very often. And I think that the job of a good mediator is not to bypass the lawyers, but to try and get to the heart of the matter with the parties. And I think that's critically important. You will often find, and this is no criticism of our split profession, barristers or solicitors who are good advocates, positioning themselves, delivering position statements and behaving like adversarial advocates. This is not really suitable for a mediation setup, and it's not what is needed.
You've got a very different forum where everyone's much more closely aligned, I guess, or trying to reach a successful resolution without all the back and forth and such adversarial.
The adversarial positioning is the right way to behave in a courtroom. If you're having to make points, to make your positions clear, but mediation doesn't demand it or require it.
So if you're advising a client to prepare for a mediation and how they should go about it, if they're attending as the party, what advice would you give them to get the most out of the mediation to hopefully resolve
I think come with an open mind. Come with kind of a good heart. You know, you need to come more with. It's quite an emotive process, I've found. So even though we think that litigation is about sort of hard-nosed, you know, facts and figures, and very often underlying all of that, there's an emotive reason why people are in dispute. And I think if you come with the right thing in your heart, you've got everything in your head because you're in the litigation. But you come with good heart and with a desire to find the best solution that you can. That doesn't mean giving up ground necessarily. It doesn't mean taking ground from the other side, but it's just having a willingness to think that this is an opportunity, and probably your best opportunity, to find a way out and to solve that dispute without going in front of a judge who's going to decide something which may not suit you. And I think all parties have the same risks in litigation. They may be greater or lesser depending on your actual case, but there is risk for everyone. And you know, any party that says, you know, we're going to win, we'll see you in court, you know, we've got no risk, they're lying, frankly, because there's always a risk.
Yeah, definitely. Well, I think maybe that's a good point to wrap it up. I think.
Well, I think it's home time.
Exactly.
We'll probably do that.
Good timing. Well, thanks very much, Adrian.
Nice.
And hopefully we can do more mediation work as part of our general dispute resolution practice. And thanks for listening, everyone.
Thank you.